Welcome, everybody. Good morning, good afternoon, good evening, greetings. We should just say greetings and simplify that.
We should, yes. We could save so much time.
So much time, yeah. Folks, as is our tradition, we'll give it a few more minutes. I look at my boss, Mandy. Boss Mandy gives me the instruction to start, and I start. And in the meantime, Mandy and I do small talk. It's New York Arbitration Week. There are more people at the receptions than at the events, but that, I guess, is to be expected.
The nature of arbitration weeks.
The nature of arbitration, yeah.
Absolutely. So my voice, I think, is about three sort of octaves lower than normal because of all the speaking at the receptions. So I have a weirdly deep voice this morning. So. All right.
Greetings on my behalf too.
Thank you.
I shall adopt the expression that you suggested. Greetings to everybody.
Thank you. We love that.
Our speakers are always more progressive than we are anyway, so
yes.
You know. All right, Dr. Dugal, you have the floor.
Thank you, and welcome to Delos Dispute TagTime Season 6. We hope everybody's safe and healthy, and we are delighted that you can join us. I'm your host, Kabir Dugal. I'm joined by my co-host, Amanda Lee, or Mandy. Mandy tells me that only her dentist calls her Amanda. Carita, Mandy and I spent a lot of time trying to come up with a tag time gesture. At Delos, we like to create creative means. The recent rope has a horse. So for tag time, we decided to be cool and raise the roof like we're in a discotheque. So we start every episode raising the roof.
Okay.
Thank you for joining us.
I didn't do my exercise yet this morning.
It's good. It's good for exercise too. Absolutely.
Yeah.
A little bit on tag time. During this webinar series, we have leaders from all around the world who engage in a substantive discussion on international arbitration. These experts will share with us their insights, their experiences. You, our audience, then have an opportunity to ask questions. And we end with our speaker tagging the next speaker. Folks, it is tag time. And folks, as you can tell, we're so cool and trendy that we're on YouTube. So thank you for tuning in. Mandy, you and I have often spoken about this, that arbitrators are super people, right? They can decide multi-billion-dollar disputes, they act as judges, they can issue billions of dollars of binding decisions with fairly limited review avenues. But here, I think, is the critical question. Do arbitrators really listen? I love it. This is such a profound and a deep question. And we have an absolutely fantastic speaker going to discuss this topic with us. Are we as arbitrators listening for real? Mandy, I think this is something both you and I have to listen to very carefully as aspiring arbitrators.
We're all ears.
We're all ears. Mandy will have the honor to introduce our speaker, but I just wanted to express my deep gratitude and thanks to Carita. This is going to be something that we should all be thinking about. Our practice is only as good as the arbitrators are. So thank you for a really great topic. Today's episode is co-sponsored by AFIA, ArbitralWomen, Arbitrator Intelligence, the Chartered Institute of Arbitrators, the Cairo Regional Center for International Commercial Arbitration, the New York International Arbitration Center, Racial Equality for Arbitration Lawyers, or REAL, LONDAP, and these platforms created by our very own Amanda Lee, like your dentist says. Careers in arbitration the one-stop platform for everything arbitration related, and the new Arb balance. Again, like our topic for today, something that we need to be thinking about a lot more. Let me just explain the process. Mandy will very soon introduce our speaker, after which our fabulous speaker talks to us for 40-45 minutes. Mandy and I will then facilitate the Q&A. Now, folks, this is the time to get your pen. If you have a question, please email us at tagtime@delosdr.org. Once again, tagtime@delosdr.org. Mandy, I love it how we do this in sync. It's become like a dance performance. Let's also just offer some best practices for Q&A. I speak, Mandy mimes. Tip 1, a question is a question if it ends with a question mark. If it doesn't, it's a sentence. Second, just to help Mandy and me, we urge you to keep your question to 3 lines or under. Makes it easier to read it out. And third, when you have an awesome speaker and somebody who serves as an arbitrator, the temptation to go beyond the topic is high. We kindly urge you to keep your topic relevant to the theme, and please don't ask arbitrators directly or indirectly any matter in which they are sitting questions related to that. We urge you not to do that. With that, Carita, we are so grateful for you joining us. Mandy, I'm going to turn the proverbial mic over to you to do the very tough task of introducing a speaker. Take it away, Mandy.
Thank you so much, Kabir. As always, I have the pleasure of introducing today's guest. Carita Wallgren-Lindholm is an arbitrator. She commenced her international arbitration practice in Paris in 1980 and received her first arbitral appointments in the early 90s. She's been listening for a long time. For the last 10 years, her practice is focused almost exclusively on arbitrator appointments, and she's also a trained mediator. Carita's been involved in more than 120 international arbitrations, institutional and ad hoc, mainly as arbitrator and mostly as chair under all the major arbitral rules and involving myriad seats. She was appointed to the ICSID panel of arbitrators in 2019, having formerly served on its panel of conciliators. She serves as an advisor to the Atlanta Center for Arbitration and Mediation. She's a former chair of the ICC Commission on Arbitration and ADR, and a former member of the ICC International Court of Arbitration. Carita has served as a member of the editorial board of Global Arbitration Review since its foundation, and she's ranked as a leading individual in Chambers Europe and Global Most in Demand Arbitrators. She's also recognized by Who's Who Legal as an arbitration thought leader. She was tagged by our recent guest, Mike McElrath, and we are extremely honored to welcome her to Tag Time today. And so, without further ado, Carita, the floor is yours.
Thank you, Mandy, and I shall call you Mandy since I'm not your dentist, I have learned this morning, and I'm now taking the time here to see how much time I have. And I liked, Kabir, your instructions regarding how to make questions, how to put them. I think that many others and the listeners to this program would benefit from those instructions. I'm not sure that you're going to like what I'm going to hear. At least I think I may suggest that arbitrators are not super people, as Kabir said. And now I shall go to the thoughts that I have assembled and share with you my thoughts, looking forward to having questions and maybe also views. So greetings, and first, of course, my thanks to Mandy and Kabir for the invitation, and to Mike McElrath for having tagged me. Mike suggested that I might wish to speak in relation to a topic that I wrote an article about in 2011 with the title predictability of proceedings in international arbitration, international commercial arbitration, and is there a Nordic way? I think that the article written for a Nordic Liber Amicorum passed rather unnoticed. It was certainly not on the New York Times bestseller list. And I sometimes think that Mike McIlrath may have been among the few that actually read the contribution. In all events, the article essentially suggests that arbitrators should first inquire with the parties about their expectations for the procedure and then set out how the tribunal is proposing to proceed based upon how they view the case and counsel's responses. Since most arbitration rules are not prescriptive regarding the detailed procedure, and since it's the application and not necessarily the wording of the rules that shape each arbitration, the article argues that the proceedings usually look like the chair. I would add that often proceedings under the same chair look the same regardless of the applicable rules or the seat. Likewise, how the tribunal directions are perceived is largely also in the eyes of the beholder. In consequence, also the communications between the tribunal and counsel risk being, at least to some extent, imperfect, since tribunal members and counsel alike take certain elements for granted regarding the base setup and procedure. As a Nordic children's book would have it, we all have different pictures in our head. In arbitration, as in human exchanges in general, we use those pictures to further develop what we hear from one another and to fill any existing or perceived gaps in each other's statements and writings. The filling material are procedural rules and concepts that we are familiar with or that we take for granted. It's often surprising how differently two sides from different legal cultures can read what a chair deems to be a perfectly standard and self-explanatory PO1. The implications of written witness statements or cutoff dates, for example, or philosophy of document production will mostly require some expansion or will at least benefit from it. I cannot count the times when one side argues that the standard writing must necessarily also imply X, Y, and Z, generating further context from the legal environment from where the procedural tool emanated. And the other side legitimately points to the fact that such ancillary consequences have not been provided for in the tribunal's procedural directions, and that the proceedings should be kind of standalone, subject to lex arbitria and the institutional rules. We can discuss examples if there is time and interest. Many counsel are not comfortable to ask questions about what is actually meant by various directions given by the arbitral tribunal, maybe out of a fear of being seen as ignorant by other participants, including their client. Tribunals may hesitate to state the obvious out of a similar fear. I recall many eyebrows raised as I have asked the parties if they have held the pen and made a first draft. What do you mean by this drafting, which admittedly often is clear on its face? How often have we not heard the expression, this is how you do international arbitration, or this is best practice in international arbitration, or this is just how things are done, and thereby by a bit insinuating that if you are experienced enough to be in the know. But sometimes you kind of feel that, even though I, of course, accept that there is an internationally accepted standard practice, sometimes people advocate somebody's view of best practice or some regional view of best practice. Many discussions after questions, if one persists, often reveal that the parties, in fact, do not share a common paradigm, even though they all profess that they practice international arbitration according to the latest state of the art and benchmarks. One would think that avoiding misunderstandings in the early procedure regarding some base procedural directions is really not rocket science. But why do genuine divergences of view still arise in practice quite frequently? Admittedly, if you have certain global firms or specialized arbitration boutiques on both sides, you may, as a tribunal, normally legitimately presume that they speak the same language also in the details. But even in such situations, much ink is sometimes spilled over explanations why a certain writing must also, in the view of one side, entail a number of unarticulated consequences because it follows from so-called standard best practice in international arbitration. As a side note and a caveat, I will note that what I'm highlighting here, of course, implies no disrespect, of course, of what is often referred to as soft law, such as IBA compilations, which I actually am an aficionado of. I think it's efficient, and I'm ready to accept as guiding principles also when not explicitly referred to. I only wish to warn against certain conclusions being taken for granted too easily. In addition to honest, legitimate differing assumptions about the matters that have not been spelled out in rules or procedural directions, while different procedural tools are used in different legal systems to achieve the same purpose, we today often see accumulation or even maximization in their use of different tools out of a fear not to leave any procedural tool unused. It takes some courage from counsel or arbitrators to ask, do we really need all this? I had a senior partner many moons ago who used to say, it is okay from time to time to also use common sense. You will understand that I, of course, accept that counsel must do all that is necessary to preserve his or her client's rights. But the skill lies in knowing what is necessary, something that requires extensive knowledge, as also courage and strategic thinking. So after this retrospective expose into an old writing, I will now get back on the rail by recalling the topic of today's presentations. Are we as arbitrators listening for real? To which I will add, are we ready to spell out what we really mean by our directions, by accepting that the obvious may not be so obvious to all? And further, are we ready to do things differently from how we usually do them? And as you have noted, I am not using PowerPoint. I think this theme doesn't lend itself naturally to PowerPoints. You will know that I'm erring into, behavioral science, which I am not qualified to err in, but I speak with the ease of the ignorant and just based upon, observations over the years. I hope in all events that my topic will qualify as substantive as requested by the host. An obvious follow-up question to, are we really listening, is if we as arbitrators are not really listening to the parties, and if we are, do not fully understand what they are saying, what is it that stands in the way? A short answer could be that we stand in our own way, at least in the following respects. A failure to recognize that communication is always imperfect, at least multiculturally and multi-jurisdictionally, and that we are not as clear as we may think. False perception of self and of our own globalization level and open mind. People who claim to be internationally minded, that's a big question that we could, it's more maybe to be discussed over a bottle of wine, but that is sometimes a false perception. I would also argue that there is a lack of humility, that we are too proud to admit we do not understand, and we are too proud to ask. And then a refusal or inability to work with and manage our own predispositions or read prejudices, and then some insecurity to go off from the trodden path. And we have often heard, I'm sure, I don't know if Mandy has heard this, I heard it as a young judge that, you know, you young people are so emotional, but I, the senior old judge, I only apply reason and rationale. And I think that if people maintain this perception of self, then of course it's difficult to listen actively. If you think I'm being provocative, I am. The above could of course have been stated more gently with a similar message. But then again, I am Nordic, and this, my presentation, is partly about multicultural communication. The remedial action that I am proposing to the above shortcomings is rather simple and essentially consists in some basic self-management by us arbitrators. Recognition that we may not be as internationally minded or open-minded as we are used to think. Most of us still lend a more active ear to statements made in a manner and from a legal culture that we are most familiar with. If you listen to a QC versus a laconic civil lawyer, not to say brutally laconic civil lawyer as we Finns sometimes are, we don't waste words when we conclude, and if it is often seen as really mastering your case if you can use few words. We need a recognition that we arbitrators, in spite of a long career, may still have lots to learn, and that the way we are used to kicking off and conducting proceedings may have room for innovation and improvement. I must say that I have certainly reached a state when I learn most from younger colleagues, including my children. We must have a readiness to expose ourselves by asking questions that we are used to think we should have the answers to. Fostering the kind of inner security that emanates from an acceptance that authority has many faces, and we need not always be the first one to offer all answers and solutions. The young counsel before us are likely to be the smart ones in the room. When it comes to actively listening, to try to understand and maybe learn, I, as a concrete measure, propose that the chair take the time to go through with the parties or spell out in great detail how he or she expects the procedure to roll out, having heard the parties, even at the risk that some may look at it as a kind of grade school exercise that you could also say about this, my presentation today. But I think that the devil continues to be in the detail of directions. In particular, I fail to understand why the tribunal cannot take the time to call on initial discussions with the parties prior to circulating a draft PO1, which draft, as we know, essentially is of a nature to lock in the procedure ab initio with only minor tweaks possible thereafter. This can actually save if you have a principled discussion and not waste time. And if everyone has bought into the way forward for real, there is a lesser chance of the arbitral procedure derailing and procedure becoming the main focus of the arbitrations, not an uncommon occurrence, to the detriment of the merits, of course. Now, I do not need to tell you that there are, of course, limits to open-mindedness and innovative solutions, or that there are situations where no one agrees with anything, and it remains for the tribunal or the chair to strike a reasonable balance between belligerent or uncooperative counterparties in order to move the case forward. The aim of this presentation is not to try to regulate pathological situations or guerrilla tactics, but just to address the behavioral human element in arbitrator attitude and encourage us all to more humbly assess our own views and reactions in the face of each new case. I also prefer to limit this presentation to commercial arbitration. Including investment arbitration would require carve-outs and clarifications. However, I obviously think that many aspects of arbitrator attitude equally can find application to arbitrators in investment cases. To some of you listeners, this may read like or sound like yesterday's newspaper if you've heard and read me before. However, and this I find a bit surprising, even though the question of customizing proceedings to the case at hand for efficiency and cost savings is debated almost daily in our arbitration community, somehow few arbitrators actually seem to practice a less templated proceedings model, and if you wish, would rather play it safe by not taking the path less traveled, to paraphrase Andrea Björklund and Robert Frost in the very recent Freshfields lecture. Actively listening to disputing parties obviously does not mean implementing anything that they may wish for, especially as they often do not agree. After all, the arbitral tribunal and its chair are the guardians of due process and stability of outcome. But it should mean listening with an open mind to suggestions, albeit unfamiliar, for a more efficient procedure, or proactively proposing such procedure, having familiarized itself with the dispute and the parties' initial broad brush views. I also think that a truly level playing field will require some active listening. What is perceived as equality of arms often risks creating a situation where one side is more equal than the other, absent some active customization. Engaging in this manner obviously requires that both arbitrators and counsel are forward-leaning and well-versed in the substance of the dispute early on so as to see how it could be dealt with most efficiently. Such exercise can involve sequencing, for example, approaching the dispute issue by issue, as is done with increased frequency, including the possibility of upfront summary dismissals that Mike McIlrath recently spoke about on this program. It can mean dissecting the dispute into the parts that require an arbitration proper, and areas of dispute that would be best solved, for example, by an expert opinion. They could even be part of the dispute that would seem to lend itself better to a negotiated settlement than to adjudication. Some of the listeners may recall that during my tenure as chair of the ICC Commission on Arbitration and ADR, we established a task force with the purpose of approaching the anatomy of disputes through the lens of customization, identifying horses for courses. The task force is led by Shan Bao, also a former guest on TagTime. I personally believe that the most important in order to achieve a culture of openness to novel approaches to dispute resolution is a dialogue. Practitioners becoming used to the first question being, what does this dispute in this particular legal environment, considering, of course, the seat, the lex arbitri, the institutional rules, call for in terms of procedure, instead of pulling out PO1 and a standard timetable calibrated with the usual milestones. When arbitrators decide to embark on a less conventional initial approach to procedure, which can also be done, for example, by combining known modules in a novel fashion, it is not, in my experience, unimportant how this is done communication-wise in practice. Anecdotally, I think it's fair to say that there is less discord when you speak to participants, at least as a first measure, instead of writing. You minimize the risk of submissions resembling ships meeting in the night. The temperature is oftentimes also lowered when counsel, hopefully together with party representatives and the tribunal, speak in person, face to face, if warranted for in the individual case or online, which oral exchanges often are conducive to reasonable alignment on the procedural way forward. It's kind of more difficult to be very difficult when you speak to people than when you sit behind closed doors and write. But discussions also allow all participants to explain their positions informally, without as much fear of compromising their rights by black letter positions, and for the tribunal to explain why it thinks a certain procedure could be an appropriate framework for resolution of the case. This approach, of course, also requires particularly that the tribunal is sufficiently knowledgeable about mainstream procedural concepts and measures in the main legal families to be able to lead such discussion and to understand what the parties are actually saying, evaluated against their legal background. Again, it goes without saying that the baseline, of course, is international arbitration as we know it. I mean, I have to say that from time to time. I'm not proposing that we go out and create all these new animals. And the better we know it, the baseline, the more confident we hopefully are to innovate around the knowns without jeopardizing the stability and finality of the outcome. Let me check. I think, yes, I still have time. An obvious carve-out is if parties propose procedures that are so unfamiliar to the tribunal, or rather to the chair who needs to lead, that she doesn't feel comfortable in conducting them. I, for example, have been in a situation where I had to decline a proposed expert procedure because I did not understand the full ramifications emanating from local curial law and was not convinced I could secure due process in the context. Today, it is often suggested that multiple CMCs, case management conferences, can be held at given stages of the proceedings to discuss pertinent issues at such stages. I would even suggest that the tribunal could call a procedural conference whenever the proceedings face an impasse in some respects to try to untie the knot and see if a solution can be found, which you often do when you speak. It is not uncommon that even sophisticated parties argue simply due to a genuine misunderstanding or for lack of a full understanding, which is, of course, wasted time and effort and cost. Another theme that I addressed in that old article is whether the choice of a seat and certain institutional rules can be allowed to create any kinds of legitimate expectations. You will know that I have spent many decades with the ICC, and we know that the ICC holds itself out as being a-national and non-regional, and rightly so. But does a seat in London, Singapore, or Hong Kong suggest a leaning towards more Anglo-Saxon or common law concepts as a default position than a seat in a minimalist civil law jurisdiction, buttoned up like Sweden or Denmark? And what about the inquisitorial tribunal-led procedure that is prevalent among many Germanic chairs for counsel who expect an adversarial system, not only in the US, but also to some extent in the Nordics? We all know, for example, about the Prague rules and the approach that they profess compared to other rules that we who are not Germanic more naturally practice. Again, to make sure that everyone is on the same page, why not raise such issues of potentially varying expectations at the outset? An interesting party autonomy topic for discussion here or elsewhere could be whether a German or Austrian arbitrator should loosen his grip on the proceedings and on the interrogations if counsel on both sides agree that they wish to be the masters of the evidentiary hearing. Or will the chair say, well, this is how I do it? Or is he prepared to think again or try again? Or she? In all events, I will answer the question to some extent, the question whether the seat could suggest a certain leaning in the procedure. I will answer it in the affirmative to some extent, such that the location of the seat and the lex arbitri, in my view, can create legitimate expectations of adherence to the local legal culture in some respects. Always on the understanding, of course, the baseline of international arbitration, especially if the chair is a product of that environment. Also, since the local courts are likely to support local approaches, for example, to the omnipresent question of whether the parties have had the opportunity to plead their case, or if the arbitrators have acted ultra or infra petita. It is, of course, impossible to know whether arbitrators sometimes are less inclined to adopt novel procedures or to engage in too much discussion with the parties for reasons outside of the here and now case. For example, for reasons of expected peer perception, like what will people say, or what will the relevant people say or think. It of course takes both confidence and courage, the latter quality, in my book, a very important arbitrator characteristic, to channel all efforts to the case at hand, just at least my Finnish bar rules provide regarding the deontological duties of an attorney as transposed to an arbitrator. The duty is to exercise the mandate without undue external influence. And I say here, of course, even aside of a normal conflicts assessment. I am not professing any, après nous le déluge type of thinking, but still, I am not amused when arbitrators lift their eyes and consider external circumstances, if you wish. While, and I am also not now addressing investment arbitration, also commercial arbitral awards can sometimes come into play in the development of the law and procedure, even though we know that, for example, in England, it is deplored that case law doesn't develop because of arbitration. It is a fair base approach by an arbitral tribunal that it owes its duties to these parties and not to future disputing parties in a like dispute, nor to counsel in future dispute, nor to their peers, and not to the development of the law. I say this, of course, it is not completely true, but as a base principle, don't look too much to the sides in my book. Okay, finally, now I'm coming to the finally parts. When asking if we arbitrators are listening for real, we also need to query whether we listen to one another for real on the tribunal. While I believe that arbitrators should exercise at least the same level of sensitivity and active listening in relation to their co-arbitrators as towards the parties, I accept that views can reasonably be different regarding the most desired dynamics within an arbitral tribunal. As for myself, my aspiration is always to have a trusting tribunal entity, aligned in procedure and speaking freely within the tribunal. Here I often say to my co-arbitrators as the chair that, please speak freely and please change your mind if you genuinely want to change your mind. But I am much for an open dialogue, even though I think that it can reasonably also be very formalistic if that is the character of the chair. But having said that, I believe we should speak freely with divergent views on the panel. I believe that the tribunal should speak with one voice towards the parties. And as a practical matter, I will always avoid going in front of the parties without having had a chance to discuss through with my co-arbitrators, get to know them if I don't know them from before, and run through how are we going to do this, and do you want to speak through me? Do you want to jump in? How do you view these principles, so that the tribunal speaks with one voice towards the parties, and look like one entity are aligned and not sort of three heads before them. This obviously doesn't mean that views cannot and oftentimes do differ on substance, of course. Another one of my pet subject is that if you have such a close dynamics and good rapport on the tribunal, then of course it puts certain limitations of the possibility, or in my book rather impossibility, to have a fellow co-arbitrator as counsel in another case. But that is for another discussion. I have had many debates on this topic, but I personally find it very difficult, at least simultaneously or close to being on the same tribunal. To conclude, Mandy, I am still within limits, right? Yes. Yeah.
Absolutely.
To conclude, in the blurb I developed for today's topic, I wrote, early procedural conferences are intended to allow for exchanges between the parties and the arbitral tribunal to tailor-make the proceedings at issue, to adapt to the parties and their dispute, all obviously within the limits of due process, and while ensuring stability of the outcome and of course predictability. I am as I already said, I'm not professing or going completely out of the box. But are we as arbitrators really listening? And if we are we capable of getting out of our comfort zone to conduct the proceedings in novel ways, to respond to the parties' wishes and to the particularities of the case at hand? I have tried to answer the call by suggesting that and how we as arbitrators could work with ourselves. And I now invite your views on these questions. I stuck out my neck and I'm ready for the feedback. So thank you for your attention. Thank you.
Thank you. This was, I have so many things I want to talk with you that I think I could personally keep you here for an hour. But I think, there's so many meta issues you have touched upon. But let me just ask you something that I think you have touched upon a couple of times. And based on your experience, I think it would be valuable. You spoke about differences between civil and common law practices, which can very significantly impact how you listen, how you ask, what party expectations are. And I just wanted to see your insights. Do you think our system has a common law bias in favor of the common law or common law practices? Because arbitration is supposed to be international, but if the system tends to favor one system, we're creating something inequitable. So would love your insights.
I will answer like this. I will answer that I think that many of the concepts are common law concepts. Production of documents. We have what we call edition in most civil law systems, and that means that you can ask for a document that you need to prove a disputed point. You can ask for a particular that you need, but you cannot ask for any surrounding things, and normally not regarding the opposing party's case in the same manner. So for example, this tool, I feel that civil lawyers that plead before me, they know the rules about document production, but the implementation is often inadequate, I think. The written witness statements is one where really it took many years for at least Nordic lawyers, in my view, the young practitioners now, of course, know to understand that in fact you couldn't call your own witness. They could read that there was only a warm-up in direct examination, but the fact that if this witness wasn't called for cross-examination, you know, you couldn't call him or her yourself. These things, I don't know how many cases I have had this, and these are not with if I'm, you know, very, you know, country lawyers who are in their first international arbitration. This has been a genuine dispute. I want to say something, if I may. This is a long answer. I don't know if you allow me to answer so long, but there is another point, of course. It's about orality and written documents. As civil lawyers, we often think that all these narratives that are told in witness statements are completely unnecessary if there is written proof of what matured. So you know, we mainly see that oral witness statements kind of support the written evidence, and we think that much of this oral testimony might not be necessary. At the centenary of the Finnish bar, I did some, which was a bit humor, but about the civil lawyers and the common lawyers, the pleading tactics. You know, I think in the old days, a Nordic civil lawyer would meet too much eloquence with suspicion. You know, too much eloquence, too much courtroom drama was viewed as suspicion. If you know your case, it's bang, 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 tick, tack, tack, like this. And I think many Nordic practitioners sometimes have to get used to thinking that eloquence is as serious as few words. And I will finish by saying, I don't know, you're too young maybe to remember Colombo. Do you remember Colombo? There was a query, I think, in the 70s in Finland, who would be the most trustworthy attorney profile in Finland, and that was Colombo, because he wasn't too savvy, he wasn't you know, too brilliant, he was a bit philosophical, and he was considered, you know, to be really trustworthy. Okay, that was the long of the short. I'm sorry.
Fantastic, loved it. I'll pass it to Mandy, who had a related question, but this is fascinating, so thank you.
Thank you.
Thank you, Kabir, and thank you, Carita, of course. I've got this wonderful visual of the tribunals as a sort of three-headed monster that's causing all manner of chaos by ignoring the parties and hearing what it wants to hear and causing all sorts of terrible things to happen. My follow-on question focuses on culture. To what extent, if any, would you say that cultural backgrounds influence a tribunal's ability to truly hear what is being said?
Enormously. That was actually my driver in all this. This is, I mean, I've been around for a while, and this is, I think, my main, really the main point. I do think that I often hear when somebody from the same culture listens to counsel from the same culture, you often hear, this really makes sense. Yeah, he had a good point. And it's obvious. And I'm not saying this in a derogatory fashion. I work with myself all the time to manage my impulses to listen more to the tac, you know. I guess I've learned by now, but it's okay to have preconceived ideas. It's okay maybe to have involuntary bias, but you need to recognize it in order to manage it. I guess that is the bottom line, really.
Absolutely. Absolutely. I think unconscious bias training for arbitrators is just as important as unconscious bias training for the judiciary when it comes to helping us.
You want to hear another anecdote? In ICCA, when there was the first survey on the Kahneman survey at ICCA, I think it was in 2014, I heard many male colleagues of in my age group say, this was so unfair. They did a query with us. This is so unfair because we didn't have time to prepare. I guess when you test your quick impulses, the idea is really not to prepare, but
yes, you have to mentally prepare to suppress your biases. Apparently, that's a little bit worrying. I think on some level.
Mandy, you will know this is among my favorite topics. So yes, you push buttons. That's why I answer so wordily. Yes.
Excellent. Well, thank you so much, Carita, for taking the time to share your valuable insights and join us for Tag Time today. Now, as our audience will know, our show is called Tag Time for a reason. At the end of each and every episode, our speaker is invited to tag their successor in the hot seat and to choose who we will be hearing from in a future episode of our show. And so, Carita, the moment of truth, who will you be tagging today?
You may not be surprised to hear that I propose a young practitioner from Kiev, the Ukraine, whose name is Olena Perepelynska. I think that she will be an excellent speaker on the next Tag Time.
Thank you very much. Well, we look forward to featuring Olena on the show soon. To our audience, thank you all for taking the time to join us today. If you registered for today's live episode, you will receive a link to the recording of this webinar in due course, accessible for a limited time only and thereafter via Delos's members area. Remember, you can always catch up with recent episodes of Tag Time and other Delos programming on Delos's YouTube channel and otherwise via its member area. So if you are looking for something to watch over the Thanksgiving holiday next week and the parade or the football don't do it for you, there is always a bit of Tag Time. We look forward to welcoming you all back on November 30 for the 5th episode of Season 6 featuring Christopher Boog. So keep an eye on Delos's website and social media feeds for further announcements about Tag Time and other Delos programming. Until then, thank you so much for joining us today. Once again, Carita, thank you to our audience. Thank you, as always, to Kabir. Stay safe, everyone, and I will now hand you over to Kabir to say his traditional goodbye.
Thank you, Mandy. And let me just begin by thanking Carita for a very insightful presentation. And I think our practice is good when we are thinking deep about some of these meta issues. So really, thank you so much for that. To our audience, thank you for tuning in. And as we like to say here at Delos, stay positive and virus negative, the virus that never goes away. With that, we will see you all next episode. Thank you. Bye.
Thank you. Bye-bye.
Thank you so much,
Bye.
Carita.
Thank you.
Thank you. Bye.